Good evening, everybody. As while we wait ahead of the start time with people joining us, we're going to wait until 6 o'clock before we start. But for those of you that are here, if you have any comments or questions or heaven forbid technical issues, you should be able to see in the top right hand of your screen an icon with a speech bubble and a question mark. So direct you towards that. Yeah, if you have any issues ahead of the start time. But we'll just wait for 6 o'clock and for other people to join. For those of you just joining, waiting until 6 o'clock before we start, if you have any issues or questions or comments, there should be toward the top right hand side of your screen a speech bubble icon with a question mark, and I direct you towards there to let me know if there's any issues or questions. And again, just for those joining us in the last few moments, just ahead of the start time, starts at 6 o'clock. But if you've got any questions or comments, issues, please use the question box. It should be a speech bubble icon with a question mark towards the top right hand side of your screen. So good evening, everybody. Thank you for joining this evening. My name is Rex Walker. I'm managing partner here at CP Walker and Son, and I'm going to start the session now on the Renters' Rights Act. So plan for this evening, we'll spend a little bit of time looking at the timeline, when we know what we know of it and when things are going to be happening, the key provisions of the Act, how we think they're going to most likely impact the tenancies that we're dealing with, a little bit on what we're doing to help prepare, and then at the end, time for questions. So just to kind of repeat that for those that have joined recently, if you have questions, comments, issues, ask you to submit those using the question box facility. That should be towards the top right hand side of your screen, an icon that's got a speech bubble and a question mark. Subject to A is having the time at the end of the session. Conscious people are taking time out of their lives, and also my ability or capacity to answer any questions. We'll do that at the end. If we run out of time or I don't know the answer, I will follow up with people. I'll follow up with people by email afterwards. You should be, and I'll double check this, but you should be, because this is the first time I've used this particular platform, but you should be getting a recording of the session. If anybody specifically wants the slide deck, let me know, and happy to provide those. So on with business then. So you'll have seen, I suspect, in the media that the bill has become an act, and it having received royal assent at the end of last month. That said, none of the provisions of the act are actually in force yet. And last week the government told us a little bit more about that. There's a small detail here of happening just after Christmas, with local authorities receiving some of their powers. These mostly relate to their ability to access property, investigate things like alleged illegal eviction, and I know that they're all gearing up for that, but it's not too impactful on us, this particular step. The one that is and we have a date now, the 1st of May. The government have announced 3 phases, and I think the first phase really deals with the things which affect tenancies and how they work. We'll cover that in a moment, but that's our kind of D-Day for the main things. They've announced that later on in the year they'll provide the powers for financial penalties. Again, I'll deal with that in a little bit more detail, just really looking at the timings here. Phase 2, which I think I would categorize as being the areas around regulation and compliance, they're due to come in late next year. And then the third phase, where they really haven't given us any time indication, relates to the areas of the Act that deal with the property conditions. I'll come with that. They're saying they want and need to consult on that. But we wait with bated breath with a view to the timings for that. So the main provisions, I've split these into thinking about different phases of the tenancy. So things that affect tenancies before they start, while they're operating, and at the end. Pre-tenancy. So one of the main headlines really, all tenancies on the 1st of May will become periodic or monthly tenancies. That applies to new ones that begin on or after that date, but it'll also apply to tenancies that are in existence at the moment. So if we agree a 12-month tenancy from the 1st of December 2025, therefore expiring end of November next year, as of May, that fixed term falls away. And the tenancy becomes periodic overnight at that stage. Doesn't matter what's gone before, but any fixed term in an existing tenancy will be replaced by the rolling tenancy. Rent in advance. So it's usually at the beginning of a tenancy, the tenant's going to pay the first month's rent in advance for the first month. There are times though, both in the student market, where it's been common for tenants to pay on a termly basis when they get their loan payments, but also in the professional market, sometimes a tenant will offer more than 1 month's rent in advance, potentially to overcome a minor stumbling block with the application. There's a slight caveat here, insofar as landlords and agents won't be allowed to ask or encourage for more than 1 month's rent to be paid, but it is possible to accept that if it's volunteered by the tenant. Now, that creates a little bit of an administrative hurdle, linked to the fact that there isn't a fixed term. So, a tenant could say, yep, look, I know I've only been self-employed for 6 months and it's hard to evidence my income during that period, but to allay your concerns, I'll pay 12 months in advance. We'd be fine to take that, but we don't know how long the tenancy is going to last. Could be shorter than that, with rent being paid in advance. So I think, landlords who receive direct payments, would need to be aware that there's a scenario in which that rent needs to be paid back. And us as agents, I think it, might be more prudent if that rent is paid, for us to hold it on account, to see how long the tenancy lasts. There's a provision to stop what they call bidding. And it's relatively straightforward. The property is advertised for rent at £800 a month. We won't be able to accept a rent, even if it's volunteered by the tenant, at a figure higher than the advertised amount. So the caveat around with first month or if the tenant wants to, it doesn't exist with this. So I think, look, there's going to be a balance here. This isn't something which is particularly prevalent in our market. I know it is in the London market. Perhaps when demand's particularly exceeding supply, but usually with our tenancies, the advertised rent is the rent that's sought. I don't know. Time will tell whether patterns of behaviour will emerge, similar to the sales market, where in certain scenario market conditions, it's common to advertise a property at 300,000, thinking that you're going to get 270 to 80, whatever it is, But with the rental market as it is at the moment, there isn't. With demand is not exceeding supply significantly, I suspect it's going to be relatively straightforward to us that that capacity to increase rents on the basis there's going to be bidding, I suspect probably won't emerge. It's been true for a long time, for understandable, justifiable reasons, that landlords, agents can't and shouldn't discriminate against tenants, certainly those with protected characteristics, so on the basis of their age or gender or ethnicity or what have you. This legislation specifically relates to families and families with children. The government have perceived that they're often blocked from accessing properties in the rental market. Not something that I would necessarily say that I've seen, but the act specific that the landlord agent shouldn't say or do or imply anything that a property isn't available to somebody on the basis that they have children. Moving on then to things that are changing. Things that are changing during the tenancy. The process for increasing rents is changing a bit. Sorry to use a little bit of jargon, but the process by which rents are supposed to be increased at the moment is via a process called Section 13 notice. And the process is going to be that rents, if they're going to be increased, have to be done via that process. You get one go at that each year, and the rent can be increased up to the market level. So a notice will be served to a tenant. Your current rent 700, and we're giving you notice that it's going to increase to 800. The tenant then can either accept that, pay the increased amount, or if they want to, they can challenge that rent increase, say that it's to a level above the market rent. Now that's the same process as it is at the moment. What's changing is some technical bits. So if the tenant challenges that rent, says no, 800 is above the market rent, they'll challenge that at the first tier tribunal. Between the date of the notice and the tribunal hearing, the existing rent will remain the same, pending the outcome of the tribunal. At the tribunal, a determination will be made on the market rent. Now, if that's to 800, if that's agreed, yes, £800 is the market rent, then the new rent will start from that date. It won't be backdated to the date of the notice. Okay, so tenant carries on paying the old rent until the date of the tribunal. And the other change from how it works at the moment is, at the moment, the tribunal determines what it thinks it's the market rent. It might think, for example, that actually 900 is the market rent, and tenants should pay that. Under the new regime, the tribunal can set a maximum of the rent that was sought via the notice. So even if the tribunal thought the market rent is 900, it would be 800 from that date. tenants will have the right to request a pet, and the landlord's under a duty to consider that. And if that request is going to be turned down, then we would need to be evidencing a good reason. Think of certain, good reasons. Perhaps in a flat, the head lease forbids it. Perhaps landlord has intentions to reoccupy at a certain point and is able to evidence severe allergies relating to to pets. But on the whole, we can see the direction of travel here, and if that request is going to be refused, then landlord, as we think we're going to need to be able to justify that. Certainly, there was some to and forth during the legislative process about whether this was going to be mitigated in any way, such as a landlord saying, yes, you can have the pet, but you must take out some sort of pet insurance to mitigate that. The government, in the end, decided that those kind of matters ought to and are dealt with via deposit. That's what the deposit's for. So if there are any pet-related issues, they were dealt with in the same way as any sort of tenant-related dilapidations issues. So these new provisions, and I'll talk about some more of them in a moment, require some teeth, and there's increased enforcement powers associated with them. So should landlord or agent breach the new rules for a first offence, they're talking about figures of around £7,000 per offence, rising to an unlimited level. Or even criminal proceedings in the most egregious of cases. They've also introduced the concept of rent repayment orders, so scenarios in which repairs weren't dealt with badly over a prolonged period of time. The local authority or the court in some cases is going to have the power to order that a landlord repays some or all of the rent during that period. We've got some increased regulation. So there's going to be deal with a database first. So every landlord who wishes to or is letting out their property is going to need to be signed up on a database. We wait for the guidance at the moment about whether or not we'll be able to do that on your behalf, or whether landlords will have to do some or all of that themselves. We also don't know exactly what details are going to be on the database, but we'd expect some landlord-related information, contact details, names, etc. I'd expect some property-related information, the ability to upload gas certificates, EPC, electrical checks, to give the government some oversight or some sight over those being in place, and then an ombudsman. So we're subject to oversight by ombudsman as an agency, by virtue of our professional membership of our professional bodies. But this is going to capture both self-managing landlords and I think potentially also landlords who use agents, possibly in scenarios where tenant feels there isn't a complaint against the agent, but there is one against the landlord. The decent home standard and AWAB's law. This is in that phase 3 that I mentioned about before. This relates to the government's desire to increase standards in properties and how issues are dealt with. The decent home standard essentially already exists by way of the HHSRS, which sets out hazards within rental properties and the need for them to be addressed. AWAB's law is the new thing, and it relates to a sad, tragic case involving the death of a young boy in a property. The property was actually in the social rented sector rather than the private rental sector, but the death was linked to mold and condensation issues within the property that weren't dealt with over a prolonged period of time. So this, again, we're waiting for some more guidance, but Awab's laws in process in the social rented sector, and we're speaking to people, and there's a lot of work being done in that area. But essentially, what it's going to do is it's going to set kind of legally enforceable timeframes for issues to be dealt with, not just mold and condensation, but other things as well. As we've been thinking and talking about this, and a number of people have I think especially with the link to mold and condensation, people have the queries around, well, hang on a minute, Rex, I had a problem with mold and condensation at my property. It was investigated. It was found to be nothing to do with the fabric of the building and everything to do with the lifestyle, how the property was being occupied by the tenants. So you're really telling me every time there's some mold, I'm going to have to go and pay for it to be rectified. I think give an example here, which might explain how I think how I would expect it to work. If there's a problem at a property today with a blocked toilet, and it's found that toilet was blocked by excessive or things being put down the toilet that shouldn't be put down by the tenant, down the toilet by the tenant. The cost of that ultimately can and should and would be borne by the tenant, and would be a similar scenario here. But this is where we have a challenge in terms of how these regulations rub up against the Tenant Fees Act, because the Tenant Fees Act gives a very short and prescribed list of things that it's legal for a tenant to pay for during a tenancy. Rent and deposit and replacement keys. There's a relatively short list. Anything that falls outside of that, like the blocked toilet example, the payment, the physical payments of it is kicked down the road towards the deposit and at the end of the tenancy. So I think we're going to be in situations where, yes, there are issues that need to be dealt with at the property. The tenant is partially or fully responsible for those. They need to be addressed now and they need to be addressed quickly, but recovery of the funds from the tenant would need to happen at a later date. Okay, moving on to the main provisions at the end of the tenancy. Another headline, another big headline area here. You'll have heard, I suspect, the government ministers crowing about, we're doing away with no fault eviction. Now, really, that, as I explain here, that's a misnomer. They're not doing away with that, but they are changing the mechanism by which landlord can regain possession of the property. But first, the tenant. So tenant will be able to give 2 months notice at any time during the tenancy, and those 2 months would end at the end of a rental period. So the absolute minimum length that the tenancy will be is 3 months. I move in, I hate it. There's all these issues that for whatever reason I didn't notice during the viewing. I don't want to be here. Give notice today. There's 2 months runs from the start of the next rental period, a 3-month tenancy. Landlord. So, whilst I think it's fair to say that they haven't got rid of no fault eviction, i.e. that there has to be a fault of the tenant for it to take place. What they are saying is that when landlords want possession of the property, they have to have a good reason, a ground for possession. And it's helpful I think, to know that these grounds, these reasons for possession, fall into two separate categories. There's what they call the mandatory grounds. Now, this means that if these scenarios, we were able to evidence that these scenarios are happening, the court must, it's mandatory, the court has to give the landlord possession of the property. And we've got two new grounds added to the existing law. Now, they are the landlord wants to reoccupy, to live in themselves or by a close family member, or the landlord wants vacant possession in order to sell the property. Now, that the devil of this is certainly in the detail. So first up, with respect to both of these grounds, those notice that the 4 months notice that the landlord has to give, that I want to sell or I want to reoccupy, but that 4 months can't expire within the first 12 months of the tenancy. So on each new tenancy, we're going to all need to be aware that if we want it back for a reason that's nothing to do with the tenant, to reoccupy or to sell, that won't happen in the first 12 months of the tenancy. I'll talk when we talk about the impacts about how I think that's going to be dealt with. But I think it's very important to understand that yes, you can get it back if you want to sell or you want to reoccupy, but B, that ain't going to be quick. And also importantly, this last bit here, if you use that ground, then you're prohibited from re-letting that property for 12 months after the tenancy ends. Okay, which I think we can all envisage quite easily that there are circumstances when that could create difficult situations. I wanted to sell the property, I've got the tenant out, we've had a go, for whatever reason, as that sale hasn't been effective. I've got an empty property, I want the ability to re-let it. You won't be able to. We won't be able to for 12 months after the tenancy that we ended by way of these grounds elapsing. They've added in a ground here in relation to properties that are occupied by students. Again, there's some caveats here that I think I'll just spend a few moments working through and explaining. For reasons that I've thought a lot about and asked the government about, but never got any answer really. They're saying this only applies to student properties where there are 3 or more occupiers. So if you've got a 1-bedroom or 2-bedroom student property, you can't use this ground. But what you can do is if you've got 3 or more, we can say to the tenant with 4 months notice, look, I want that property back on a date between June and September, because I've re-let it, or I want to re-let it to another group for the next academic year. But, and I think probably a big but, particularly for how the student market works, we have to have told the tenant before their tenancy started that we might do that. That's fine. Put that in the tenancy agreement, no issue. But what they're saying is, if that tenancy agreement was signed 6 months before it started, 6 months or more before it started, you can't use this ground. Now, there'll be if there's people, there'll be clients here who potentially only have student property. There'll be clients that have either, and there'll be plenty of clients that don't have any student property, and they might be thinking, Rex, why are you stressing this? This sounds a bit silly. Why would we be signing a tenancy agreement with somebody 6 months or more before it starts? Well, the student market is perverse in a number of reasons. One of the ways in which it's perverse is there's a lot of forward letting. We are advertising now and agreeing lettings now for student properties for tenancies that are going to start in August and September next year. So way ahead of the 6 months. Why they put this in there, I don't know. To be honest, I'm not overly concerned about it. The vast majority of student tenancies end naturally, if you like, and they often end naturally at the right time. They're Some tenancies renew for another academic year, but most last a year. They're either graduating, they've fallen out with each other, they've got a new friendship group, whatever it is. I think we'd potentially have a balance. I think we'd be probably making a mistake if we didn't agree the lettings earlier on the basis that we want to be able to serve this notice. I think we're probably of the view that if you've got a tenant ready to go now, let's get them signed up, and we'll deal with end of tenancy at a later date. I've added a couple in here if there's substantial redevelopment, the tenant can't live there. That's another mandatory ground. And then there's one here with respect to antisocial behaviour. I suspect I'll bring your attention towards ground 8, which is changed from the existing rules. The existing ground 8 applies when the tenant is 2 months in arrears at the time of the notice and the time of the hearing. That's being increased to 3 months. So if the tenant owes money, the judicial process can't start until 2 months and 1 day of no payment, until they're 3 months in arrears. And they would also still need to be at least that level in arrears at the time of the hearing. So they're the main mandatory grounds. You can see from the numbering that there are some that I've excluded there about priests needing it for religious accommodation, things that don't come up from time to time. But in terms of the discretionary grounds, so these are situations where the landlord still needs to provide evidence and convince the court that these grounds apply. But even if they do apply, it's up to the court to decide whether or not to grant possession. And you'll see here that there are 2 that relate to arrears. So these would be scenarios where the 3-month test hasn't been met, where you must have possession, but perhaps there's ongoing what they call persistent arrears that is less than the 3 months. It will be left to the hands of the judge to decide in the circumstances, with that being evidenced, whether or not it's fair, reasonable, just, equitable to grant the landlord notice. But it does, one of the messages I'm trying to explain here is 3 months in arrears isn't the only set of circumstances in which possession can either start or be granted under the new rules. Breach of tenancy kind of covers all the non-rent related stuff, and I think you'd be most likely to sort of see scenarios where there are significant issues with property care, and then there are a couple of examples here that unfortunately do from time to time crop up. Perhaps one being less serious antisocial behaviour than the mandatory ground, and also one relating to domestic abuse, when the victim of domestic abuse has had to flee the property. There's other person or people there who you'd anticipate being the perpetrators. In those scenarios, there's a ground here for getting possession. So that these are the main scenarios, at end of tenancy, where where landlords will be able to and will be seeking possession. So turning then to likely impacts. I gave that kind of extreme example of how short tenancies could be. Look, what is clear is the new regime creates probably additional uncertainty about how long tenancies are going to be. It creates the scenarios where if the tenant wants to leave for whatever reason, they don't like the property, they've got a new job in London, whatever it is, they're going to be able to go. As is the case at the moment, whenever that fixed term ends, but we won't have the we won't have the benefit of being pretty confident that the tenancy is going to last at least as long as a 6 or 12 month or any other term. I think it's probably easier to overemphasize this or think this is a bigger issue than it is. When we look at the vast majority of tenancies, I think it's true to say that at the moment the tenancies tends to, a significant majority tend to last as long as the tenants want anyway. And the tenancies that don't end when the tenants want, although are ones that I think will be covered by one of the points on the previous slide. Now, I think it's almost inevitable that if that happens, that process is going to take longer. But I don't think it kind of necessarily materially changes the circumstances in which or why a tenancy, would end. One area that I think probably is being underappreciated at the moment is what's going to happen when there's a joint tenancy, and that could be, A and B moving into a 2-bedroom flat, could be a professional HMO or a kind of classic student tenancy. In these scenarios at the moment, especially early on, whilst there is a fixed term, we've been shielded from the impact of this because it happens. For whatever reason, A and B move into the property, they're there for 12 months, something happens, one of them wants to go. Well, whilst that's during a fixed term, we've been saying, well, you've got a tenancy for another 5 months. You need to find somebody else, or you need to pay. We're expecting and we're due the rent for that property, at least until the end of the fixed term. So these kinds of issues, as I said, we've been kind of shielded from. The intention of the legislation is that if we do have that scenario of A and B wants to leave, they're now going to be able to serve their 2 months notice, and at the end of that period, they can, quite rightly sail off into the sunset. Now, there are certain scenarios arising from that which are straightforward. If a replacement comes along and we can sign a new tenancy, great. If A wants to leave, then we get vacant possession and we're back to square one. That's quite straightforward. What's less straightforward is when one of the parties wants to go and the other one doesn't. I think probably time prohibits explaining this with kind of more kind of specific hypothetical scenarios. But what I do think is clear is those issues are going to need to be dealt with on a case-by-case basis, because I think there can be scenarios where whatever's going to happen next is agreeable to landlord, and there will be scenarios in which what's proposed going to happen next is not agreeable to landlord, and we'll have to deal with that. As I said, I think really on a case-by-case basis, but it's an area that we're very conscious of, being on top of from the beginning, because everybody's going to have to get used to a different way of working in these situations. So the stuff around regulation and decent home standard, look, it's inevitable that there's going to be an increased focus on everybody with respect to timely arrears. And I'm not just talking about the potential threat of civil penalties or what have you, but we know that if things end badly or things don't go the way that we want and we are looking to regain possession, there's going to be court hearings. There's going to be tenants saying, yes, but what about this that wasn't done here, there, or everywhere? And, making sure that repairs are dealt with expediently, quickly, and properly the legislation provides the backdrop when that's going to become even more important than it is today. I talked about the tribunal system, and they're going to likely be, we would anticipate they're going to be dealing with significant amount of rent increase appeals. I'll come back to that, in a moment, but on one hand, I think it's true to say the way that the rules have been set up, the tenant's got no reason not to challenge a rent increase. And similarly with the court system, anybody who's got any involvement whatsoever with UK courts of any type, I know that criminal cases, for example, you're hearing about being listed for trials in 2029. Admittedly, this is not in the criminal jurisdiction that we're going to be doing the county courts in terms of getting possession. But anybody that you speak to, the view that the system's already under strain. And I think one of the impacts of getting rid of Section 21, most of those proceedings have concluded without court hearings, whereas under the new regime, all of the proceedings are going to involve court hearings. So I think you have to be a genius to work out what the strain is going to be on the court system. I think on rent increases, one thing that is clear to me that the way they've set up the provisions here is that once you've given your tenant the notice of the rent increase, you're then able to enter into negotiations with them. Okay, so quite simply put, you've got a rent of 700, you think the market rate is 800, you give them their notice to 800, you do then have the ability to negotiate with them after that. You have to serve the notice first, but once you've done it, you can then negotiate with them. So that just, goes along the line, it will go along, that at least gives the tenant some jeopardy. So, you're paying 700, we've given you notice of 800, if we get noise that we think they're not happy with it, we might be able to agree to 750, which once they agree, they start paying from then, and avoids the possibility of them being adjudication going against them for 800 later on. So I think, I certainly think that will happen, and that's certainly in that landlord's interests. The other thing that I anticipate happening, linked to the increased burden on the court, is with respect to possession proceedings. I would anticipate that there's going to be there's going to be efforts by landlords to end tenancies by negotiation rather than through the court system. And really, I think that's going to look like offering the tenant financial incentives to leave. So thinking back to that scenario in which, okay, I want to sell this property, I need to sell this property, I want vacant possession. There's the 4-month notice period to consider. There's the initial 12-month period that I can't use it. And then if I do use it, I've got the 12 months afterwards that I can't relet. Right? We can go down that road, that's fine. I think a lot of people will be thinking, okay, tenant, listen, I'm sorry for this, but my circumstances have changed. I need to sell this property. I'd like to do that in a way that is upheaval for you. I'd like to do that in a way that is supportive or helpful to you. Listen, if you're gone by this date, I will give you X. And I think that whilst that may jar with a lot of people, I just strongly suspect that people will look to do that to avoid the delays and all the ramifications involved with the Section 8 possession proceedings. At letting stage, you get some applications that are great and were proved to be great through referencing. You get some applications which are poor and are either rejected before referencing or fail on referencing. there's a fairly sizable chunk of applications which kind of fall between the two. Could be a scenario, I don't know, somebody's relocating back to the UK. I've lived abroad for 10 years. You know, I've got no credit history in the UK. I'm going to be self-employed when I get back. I've got savings. You know, we can't ask them to give us their 12 months in advance. So, you know, but their circumstances are such that they don't provide any adverse information to us, but perhaps they don't provide enough positive information for us to get through referencing. And with our ability to take 1 month's rent in advance constrained, I think we could foresee that's going to create scenarios where we have tenants, where we have applicants who won't pass referencing but look good. How that's dealt with, both, you know, on a CP Walker level, and, you know, also perhaps in industry on a wider industry level, it's going to be something that I'm paying kind of close attention to. I've talked about negotiating rent increases as part of the process, as a tool to avoid delays from appeals. There's a lot of uncertainty when the new regimes kick in. You know, are tenants going to know, for example, that they now have to give 2 months notice? You know, or are they going to look at their tenancy agreement that they signed last year, where it says, you know, I have to give a month's notice at the end? There's a whole range of case law associated with ASTs, short tenancies, and how they work in almost every situation. That's all going to fall away. So until we have, you know, there'll be I know there's going to be plenty of situations that we don't know for sure what the best or most appropriate course of action is, and on some of those areas, until case law emerges, we won't know. You know, and then I think more widely, there's going to be impacts from this on the general market. Certainly true to say that there are more people at the moment landlords exiting than there are joining. Potentially, well, certainly outside of kind of corporate investors. But that's going to have an impact. I suspect in the kind of medium term, that's going to have an upward pressure on rents as supply decreases, but demand doesn't go away. That has been a kind of steady pattern when the government have intervened in various ways previously. But of course, I don't, whilst I like to think I've got relevant experience to be able to judge that, one never knows. And there's a big event happening this week in Westminster, which is likely to have significantly more impact on the general market than these legislative changes have. So I'm nearing the end of our bit, and I can see, I believe you can't see, but I can see that there have been some questions submitted using the question box up there at the right hand side. I will get those. I'll turn to those in a moment, but if you have anything that you want to ask, then now's a good time to be doing that. So in terms of what we're doing, that we've got to go back to square one with respect to documentation and procedures. That process has started and is well underway, but it will be really helpful to get early guidance, the guidance that the government have published, to be issued to us relatively quickly. Certain things that they need to be prescribed in tenancy agreements and how they're going to work. But it really is going to kind of cover every touch point for us. So that works ongoing. I mentioned referencing. We're in a world where people who try to defraud us and landlords is becoming more sophisticated. So we've gone out, looked at the market, and invested in what we think is a strong, robust outsourced specialist referencing provision. Rent guarantee insurance. rent guarantee insurance is something that's is in the market and has been in the market for a long time. I've lost count of the number of cold calls that I've taken over the years from people, you know, hello, I'm from so-and-so, are your clients interested in having their rents guaranteed? You know, yeah, of course the answer to that is yes. You know, then I ask them about their products and give me the details of it. And then after they've spoken for 5 minutes, I say to them, I thought you said to me, are my clients interested in having their rents guaranteed? You know, I've never, up until now, I've never seen or been happy enough with a rent guarantee insurance product, either with respect to the policy details or with respect to the compliance around it, to be in a position to recommend that to our clients. I am now in the new regime, have reviewed that belief, and I think that given that if a tenancy is going badly and the additional court burden and everything linked to that, if it's in relation to arrears, I think we are now certainly in a situation where, you know, we need to be, well, we will need to and will be, you know, recommending products that will give our clients protection in those kinds of scenarios. I'm not in a position to confirm that today. You'll appreciate there's lots of upheaval from these kinds of providers linked to the new act, but we are well progressed with that. And I think I'll just say at this stage, you expect additional communication from us in the lead up to the new regime starting about rent guarantee insurance products, and for you to consider about whether or not you think that's the kind of cover that you want to have. And then finally, education and training, obviously both internally, we've got our staff, you know, needing to be upskilled in this regard, evenings like this with our clients, you know, and also there's plenty of work to do in relation to the tenants as well. Okay, so turning to questions, there are a few that have been submitted here, and we've got 10 minutes or so, which I think will give us good time to get through that. So I have a question about whether we're doing notes. Whether we have the sessions being recorded. You'll receive that by email following the session. I think, as I said earlier, if you prefer or want to have the slides that we've been using here in addition, please email me. I'd be happy to provide those. I had a question with respect to funding the cost of the rent tribunal. It's free to the it's essentially free to the tenant's application, and it's free to the tenant. The short answer, there is a technical, if there's an application, if there's an appeal from that to the upper tribunal, then there is a cost, but that cost falls to the tenants. They've got another question with respect to that. What are the provisions if there's an unreasonable delay to a tribunal? There aren't any. The government have said that this is something that they are aware of, and they have said that if the tribunal system becomes too blocked up, then that they will review this piece around whether it's backdated. I don't think it's too political of me to say I'm not holding my breath in that regard. And I think it just highlights the point about, you know, my colleague Kirsty, who handles the majority of our rent increase process, she doesn't think that it's a not dissimilar scenario at the moment. You know, she thinks that, look, tenants, for all we like to moan about them, you know, are savvy, you know, and they know what the market rents are. And I suppose, and in life, most people are reasonable. So our view at the moment is that we don't anticipate it being you know, a real bloodbath with respect to I can't get any rent increases through because everybody's, you know, every single one that I've put through is being challenged and we're not getting the hearings. Next question is, will this supersede the current licensing arrangements? For example, Nottingham City Council of selective licensing, there are various licensing schemes. I'm smirking because this has been a consistent point of my feedback to them. Not in the short term. It really, I think it is highlighting, I think, that some local authorities, particularly one very close to here, you know, has undoubtedly been using the regimes to cover their financial situation. So, look, that is something that is definitely being raised to government, but I suspect they're getting kickback from the local authorities in respect to that. It would be the obvious thing to do, wouldn't it? Where you're regulating, we're all over here. Why do you need the licensing scheme? You know, totally see the point. Next question, you know, will contracts signed prior to the 1st of May have to be updated for the new changes? For example, 2 months notice from tenants. Whilst we are anticipating this being part of the guidance, it's clearly something that we've thought about. At the moment, my expectation is no, that won't need to happen. You know, that the existing tenancies will, it'll in effect be superseded. The notice provisions will be superseded by the new regime. It could be something that you know, it could happen. You could do it. I don't think there's necessarily going to be a need for it to happen, you know, and therefore the questions that we're still working through is with respect to, you know, what, if any, are the advantages to landlords of the new ones being dealt with. I think when it comes to 2 months notice, you know, I question really whether landlords want or need that. You know, 1 month, I think, is probably about right. The lettings market is, you know, is more wham bam thank you man, for want of a better phrase, i.e. with that, you know, I mentioned the forward letting that happens in the student market. That hasn't historically happened in the professional market. And what we see is, you know, when you're at, on the occasions where we have been advertising properties that are available 6, 7, 8 weeks ahead, we don't tend to see the interest that we do for properties that are available now. So, yeah. There's just a couple of, in the 5 minutes that we've got left, there aren't any other questions in the question box at the moment. I took the liberty of either preempting or just putting down some of the questions that people have been speaking to us about prior to this. So what should you be doing now? I think generally on the main stuff, leave it to us. I think the one area where I think it's important that you give consideration to is if you have a tenancy or a tenant that you foresee for whatever reason that you want to, that you like it to end, seriously considering a sale, you know, seriously considering moving back in, or, you know, perhaps it's with a tenant where there's low level, you know, where there's the kind of lower level disappointment with or disgruntlement with, you know, in those circumstances, we need to be knowing about it now, you know, and potentially issuing notices now rather than waiting for the new regime to kick in. Section 21 notices can still be served from now up until May. So if we're in that scenario, let us know. Will I be able to get my property back? I think there's quite a lot of scaremongering in this area. Hopefully we've covered that earlier on. You know, this is something that we're being asked a lot. How do I get around it? I think that there's one area of exemption, which is for purpose-built student accommodation, like halls type accommodation. You know, we're talking to our clients for who that relates to. I think they are going to be exempt from the legislation. But look, in general terms, you know, the will of Parliament's clear, and you know, where things, I'm sure people will try for work towards workarounds, but looking at in the areas where this has happened before, courts look poorly on practice, which is has clearly been designed to circumvent the will of Parliament. So I think the short answer to it is no. And then I won't go back over this, but just to repeat that the scenarios that are going to emerge when some but not all of the tenants in a joint tenancy want to leave. There's a significant amount of acclimatization to do around that, and also really where we will need to be looking at things on a case-by-case basis. Okay, so I haven't seen any other questions pop up here, so I think then it just falls to me to say thank you very much for taking the time out for this. I hope it's been useful and informative. If any queries that you might have, please contact me, phone, email, whatever. I'll be happy to deal with those. And I hope to speak to you all relatively soon. Thank you very much. Good evening.